Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the topic of release of seized vehicles by the court, which is covered under section 451 till 451 to 457 CRPC. Please remember. So, Justice Natarajan of Karnataka High Court, in the case of Javvaji Dharmateja and others versus State of Karnataka, in criminal revision petition number 9257 by 2042 on 27/10/2022, held that release of the seized vehicles under section 451 CRPC cannot be refused. A release of the seized vehicles cannot be refused on the grounds of identification issues, etc. So these are quite common things. I will tell you in an example manner. Suppose a case of road accident has taken place where 3 or 4 persons died. So in that case, if a car is involved, then the car will be seized as a material object by the police, and it has to be produced before the court, and it has to be marked an exhibit during the trial. 1 point. Second, a motorcycle is involved in a murder case of 302. The police arrest the accused and seizes the vehicle also. Present mobile phones like that. They will send them to the court, or motorcycle or lorry, things like that. They may be kept in the police station also. So they will write Form 66, they will seize the property, and they will send a note to the court also. Both things can be done. That is, if the police seize the property, they can produce it before the court, or if the police seize the property, they can keep them in custody and send intimation to the court. These provisions are there because there is no sufficient place for the court to keep the vehicles, lorries like that. So in such a case, after some time passes, what happens? The vehicle, the iron gets rusted. You all know this. The tires will get deflated. Due to the heavy weight, the tires get deflated, and ultimately it gets damaged. Who is going to benefit by this? వెహికల్ అక్కడ ఉంటే చెడిపోతుంది, అలాగే గాలి పోతుంది, ఇంకా చెప్పాలంటే కొన్ని పార్ట్లు పోతాయి. ఎందుకు పనికి రాకుండా పోతుంది? అది బెటరా? Using the vehicle and producing at the time required, is it better? Yes, the second is always better. So anyway, as advocates, we all know that we file memo or we file petitions under section 447 CRPC for release of the seized vehicles. In such circumstances, the police or the prosecution, definitely they will say that these vehicles are necessary to be marked as exhibits during the time of trial. So it is the discretion of the judge. If the magistrate thinks that the seizure of the vehicle or the detention of the vehicle is 100% necessary, he will not release. If he is a liberal person, what is there? They will produce at the time of trial. Yes, they can release them. So here, one such case has happened to Javvaji Dharmateja. So the trial court rejected his application under section 451 CRPC, stating that basing on the theory of the prosecution that the vehicle is needed for the identification, for identification at the time of trial. So it has refused. So therefore, he has approached the Honorable High Court of Karnataka. So the matter came before Justice Natarajan. So it is a vehicle, that is a lorry. For example, maybe a car, maybe a lorry, whatever it is. So since the trial court has refused the release of the vehicle, they have filed an appeal, that is criminal revision petition before the High Court. That's why please remember, in CPC classes, I have been telling you that whenever you are not satisfied with the judgment given by a court or with the decree, then you can go for the appeal. In CPC, there is a provision called a second appeal. which is based on a substantial question of law, and it can be filed only in the High Court. That's one point. Second, in CPC, please remember, whenever any order is given like this, release of the vehicle. So if you are not satisfied with the order, you can go for revision. Even CRPC also says like that. Now they have filed a revision petition, right? So the High Court relied on the very famous case of Sundarlal Ambalal Desai. Sundarlal Ambalal Desai versus State of Gujarat 2002, in which the Honorable Supreme Court of India held that the vehicle should not lie idle in the PS because it gets rusted, the tires get deflated, it will damage if the iron parts are not moving. So therefore, in this context, it is better to release the vehicle. Of course, the magistrate, he held that the trial will be impeded. There will be an impediment to the trial if the vehicle is not produced. Yes, you have to take care of that also. Suppose if the magistrate releases the vehicle, then it has met with some accident. What happens? Suppose if it is committed theft of, what happens? It cannot be produced. It happened in my case also, right? So therefore, with the future thinking, the trial court refused, but Supreme Court stated that the magistrate cannot do such things in good perspective. Of course, it is the prerogative, but in good perspective, better to release the vehicle. So if he has got any doubt that the vehicle is not produced, he can take photographs of the same. He can take an assurance from the owner of the vehicle. Then where will the vehicle go? So this is the actual liberal attitude, liberal interpretation by the Honorable Supreme Court of India in the case of Ambalal Desai. Now, with this, the Karnataka High Court held that the impugned order by the trial court is set aside. So therefore, as the vehicle can be released with the bank guarantee given by the owner of the vehicles, and the investigating officer will take the photographs of the vehicle and produce the same before the court. So anyway, very good judgment by the Honorable High Court of Karnataka. Please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.